Hi everybody, welcome to the second lesson for Legal Studies 3-4. In today's video, we're going to go over Victorian Legal Aid, Community Legal Centres, Committal Proceedings, Plea Negotiations and Sentence Indications. Victorian Legal Aid is a legal representation body which is funded by the government but operates independently, and Victorian Legal Aid seeks to improve access to justice through its provision of free legal advice and low or no cost legal representation. Whilst Victorian Legal Aid seeks to provide legal services to those who would be unable to afford it otherwise, it is very limited in its ability to provide these services. This is primarily because of its high eligibility criteria, which involves income tests, merit means test, which looks at the accused assets, and merits test, which is the likelihood of the case succeeding in court. So in those three combined acts a very high threshold, and it means that a very large proportion of society is ineligible for Victorian Legal Aid, even though they may not have otherwise been able to afford it. Furthermore, Victorian Legal Aid is heavily underfunded, and for example, in 2017, Victorian Legal Aid had to turn away 32,000 people who were actually eligible for its services, but they just didn't have the resources to take on their cases. Victorian Legal Aid has four main services. It's representation in court, duty lawyers, which are rostered on at the Children's and Magistrates Court, and they will represent an accused for a one-day appearance. This isn't representation for trials, it's only representing the accused for very minor appearances such as bail applications or presenting documents to the court. And again, it's not widely accessible as it's income tested, and priority is given to individuals based on their circumstances. Victorian Legal Aid does, however, provide free legal information on their website, which is a good start for self-represented parties, and they do have over-the-phone information and advice. Victorian Legal Aid upholds fairness as it ensures that individuals are able to obtain a better understanding of their legal rights. When Victorian Legal Aid provides representation and duty lawyers, they act as an advocate to uphold individuals' rights and ensure that the court processes are followed. This ensures that parties are treated the same in court and that a self-represented party isn't disadvantaged because they are unaware of their rights. Equality is upheld as it ensures that individuals of low socioeconomic status have the opportunity to present their case, and they're not disadvantaged due to the lack of funds. Victorian Legal Aid also upholds access by providing the accused with an opportunity to rebut the charges against them at a low or no cost. However, fairness is not upheld due to delays which the court may administer in order to allow the self-represented party to obtain legal representation. Delays can reduce the accuracy of the evidence, which may affect the overall verdict and its ability to reflect the actual crime. Furthermore, Victorian Legal Aid fails to uphold equality because the DPP prosecution has a significant amount of resources, and they are at a clear advantage in comparison to Victorian Legal Aid, which is heavily underfunded. Access is failed to be upheld because of the high eligibility criteria. The means, merits, and incomes tests mean that it's not widely accessible to society. Next, moving on to community legal centres. Community legal centres are, in essence, quite similar to Victorian Legal Aid, as they provide legal advice and seek to uphold access in the community to legal services. Community legal centres are independent, but they are government funded, and there are 50 community legal centres across Melbourne. So they're usually distributed across suburbs, pretty easily accessible to all Melburnians, and that upholds access in the sense that people can just drop into a local community centre and gain some legal advice. One of the weaknesses of community legal centres is that they very rarely actually represent parties in trial, again, because of the lack of funding provided to them. They don't have the resources to take on criminal cases and trials, and very, very, very rarely would they ever take on an indictable criminal offence, which would take significant resources and lengthy trial period. There are two different types of CLCs. First is your general CLC, which provide legal services to people in a geographical area. So, for example, Fitzroy Legal Service, that's accessible to people in and around Fitzroy, whereas specialist CLCs provide legal advice on a specific area of law or to a specific group of people. For example, there may be CLCs which provide services and are experienced in issues regarding refugees or women, and also youth law. CLCs are accessible again because you do not need an appointment, and you can just drop by if they have the time. They will, provide you with some legal advice and read over any documentation that is relevant. However, much like VLA, they are heavily underfunded. And in 2017, they were forced to turn away 160,000 people. CLCs uphold fairness as, like VLA, they uphold fairness by providing information about individuals' rights and how to better present their case. Whilst they don't actually represent parties, they give them information about how they can pursue their rights in court and ensure that they are treated fairly. CLCs uphold equality because it ensures that the accused has the same opportunity to present their case, and that they're not disadvantaged due to a lack of funding. And CLCs uphold access by being no cost and also easily accessible with the fact that you can drop in without an appointment. CLCs do not uphold fairness as they rarely take on criminal offences, especially indictable offences, and therefore do not really act as an advocate for individuals to ensure that they are treated fairly in court. They can only give information. CLCs also do not uphold equality because they prioritise individuals based on their circumstances, and this may mean that a party is disadvantaged because they're forced to self-represent themselves. Furthermore, CLCs fail to uphold access because they rarely take on indictable offences, and they very rarely actually represent individuals in court. And so this reduces their ability to allow individuals to make use of court resources and processes. Next, we move on to committal proceedings. So committal proceedings are pre-trial procedures for all indictable offences where the accused pleads not guilty. Committal proceedings are a pre-trial procedure which is heard in the magistrate's court. What happens is the prosecution presents all relevant evidence, and the accused can question the prosecution's witnesses and also make their own submissions. By allowing the prosecution to present all evidence, the magistrate will determine whether or not a prima facie case exists. That means whether the prosecution has enough evidence to secure a guilty verdict at trial. That upholds the presumption of innocence, because if there's not enough evidence for the prosecution to uphold the burden and standard of proof, then the prosecution should not be continuing with their case. Another purpose of committal proceedings is to facilitate a guilty plea, because if the prosecution presents a lot of strong evidence, it may help the accused to realise that they don't have a very good chance of succeeding, and that may encourage them to facilitate an early guilty plea. Another point of committal proceedings is to allow the magistrate to consider whether it's possible to have the indictable offence heard summarily. So going back to the first video about having the benefits of a summary offence rather than an indictable offence. Another purpose is to save court resources, because, as we said before, it facilitates a guilty plea. So, and it also, the DPP may wish to no longer continue with their case if they realise they don't have enough evidence against the accused. And so that reduces the amount of cases going to trial, which saves courts resources. And it also ensures that the accused has a better understanding of the case against them and can prepare accordingly. Committal proceedings are advantageous because they save time and money by facilitating an early guilty plea. They also give the accused an opportunity to prepare and understand the claims and charges against them. As we said before, it also upholds the presumption of innocence, as the onus is on the prosecution to present all their evidence, and from that, the magistrate will decide whether they should continue to trial or not. However, the committal proceedings and pre-trial procedures add to the cost of delay, as legal representation is required, and it just adds a process into the trial, and so it pushes the trial date back even further. It can also be seen as unnecessary, and there are calls for committals to be abolished, especially for cases where there is very, very strong evidence against the accused, or it's kind of without question that the accused is guilty. Furthermore, and probably the biggest flaw of committal proceedings, is that the prosecution can continue with the trial even if the magistrate decides that there's no prima facie case. So even if the magistrate decides that there's not enough evidence against the accused, the prosecution can continue their case and continue to trial, which undermines the presumption of innocence. It also may provide the victims with unnecessary stress, as they're required to give evidence on 2 occasions. In regards to the presumption of innocence, the committals uphold fairness by upholding the presumption of innocence, because the prosecution has to present all the evidence to show that they have enough to support a conviction. Also, the committal proceedings uphold equality, because both parties have the opportunity to present their case and question witnesses, and therefore can prepare accordingly. Access is upheld because it facilitates an early guilty plea in some cases, and therefore reducing the costs and time, because this trial is avoided. Committals fail to uphold fairness because they add to the delay, and delays, remember, can undermine the credibility of the evidence and the witnesses' testimonies, which may mean that the verdict does not reflect the facts of the case. Furthermore, and one of the biggest issues, is that the prosecution can continue with their claim even if there is no prima facie case, which undermines the presumption of innocence and may mean that parties are treated unfairly. Equality is undermined because legal representation is required, which is adding to costs, and that may mean that the accused is at a disadvantage if they do not have the funds. And further, it undermines access because costs are increased and delays are incurred. Moving on to plea negotiations. Plea negotiations are private discussions between the prosecution and the accused, where the prosecution provides the accused with incentives to plead guilty at that point in time. So the prosecution determines what charges the accused would be willing to plead guilty to by agreeing to combine the number of charges or diminishing the severity of the charges. So the prosecution will say, you've got 5 charges, let's knock that down to 2 and you'll plead guilty now. Or instead of being charged with aggravated assault, we'll just knock it down to common law assault and you'll incur lesser penalties. The purpose of that is so that trial is avoided and the parties go straight to sentencing. Usually that means that plea negotiations occur prior to trial, but it can also occur in the early stages of trial before significant evidence and time has been involved. Plea negotiations are usually only successful or usually entered into where the prosecution does not have an extremely solid case against the accused, because plea negotiations is essentially a compromise. The prosecution wants a guilty verdict, but they also want to get a harsh penalty. And so by agreeing to reduce the severity of the charges and the penalty, they're kind of not fulfilling their main purposes. So it usually only happens in cases where the prosecution isn't 100% certain with their case. The purpose of plea negotiations is to facilitate an early guilty plea due to the fact that it reduces cost, time, and stress for all parties involved and court resources. It also intends to secure a guilty plea which reflects the severity of the accused actions. The prosecution doesn't want to secure a guilty plea where the charges are too lenient and do not actually reflect the accused's actions. Another strength of plea negotiations is that if there's no negotiation, if there's no deal entered into, anything that's said in the negotiations cannot be used as evidence against the accused. So even if the accused admitted to committing a crime or agreed to pleading guilty to something but then decided not to later on, that can't be used against them in court. Victims can also be consulted through negotiations and ensure that they are happy with the outcome. As I've already said, plea negotiations are beneficial because they reduce cost, time, and stress for parties and reduce court resources. Also, victims are avoided the inconvenience and trauma of trial. For the accused, it's beneficial because they receive a lesser sentence or a less significant charge. A weakness of plea negotiations is that often the victims and the community may feel that the accused has been let off and that the sentence is too lenient. It also may mean that it doesn't deter the accused from reoffending. A weakness of plea negotiations is that self-represented parties may be forced to plead guilty to something that they don't understand the implications of, because the prosecution is highly experienced and will use legal jargon to encourage the self-represented party to take the deal. A weakness of plea negotiations as well is that it avoids the need for the prosecution to discharge the burden standard of proof, which may be seen as undermining the presumption of innocence. Another issue, sort of similar to the fact that the point about the self-represented parties being forced to take a deal, is that discussions are private, so there's no way of knowing whether court processes have been followed and whether discussions have been fair. Plea negotiations uphold fairness because they cannot be used as evidence against the accused. It also upholds fairness where the sentence reflects the accused actions. And it also upholds fairness where the victim can provide input into the decision. Plea negotiations are upholding equality because both parties have the same opportunity to be involved in discussions and achieve a mutually beneficial outcome. Access is upheld because parties are encouraged to facilitate an early guilty plea, which reduces costs and time of trial. Fairness is undermined because the prosecution does not need to discharge the burden standard of proof, which undermines the presumption of innocence. There's also a lack of privacy and transparency, as the discussions are private and there's no way of knowing whether the court processes are being followed and whether parties' rights are being upheld. It's also unfair if the sentence or charge that is agreed upon does not reflect the facts of the case. Plea negotiations undermine equality because the self-represented party may be disadvantaged due to their lack of socioeconomic funds and therefore may be manipulated to accept a deal that they don't understand. Plea negotiations also undermine access because if parties are unable to reach an agreement, it just adds to the delay. Next, we move on to sentence indications. Sentence indications are where the judge provides the accused with information regarding the likely sentence that they would receive if they pleaded guilty at that moment in time. When the judge provides an indication, if the accused agrees to it and agrees to accept it, then the judge cannot impose a more harsh sentence than what they indicated. So if the judge indicates that the accused would likely receive a non-custodial sentence of 6 months, they can't then say, actually, we're going to charge you with a non-custodial sentence for 3 years. And so we refer to sentence indications as a sentencing discount because it provides a benchmark for what the accused can receive. There's a difference between sentence indications for indictable and summary offences. So for indictable offences, a lot less information is given. The judge will only tell the accused whether the sentence is going to be custodial, involving imprisonment, or non-custodial, such as a fine or a CCO. Also, the prosecution must give permission for the sentence indication to be given. And this is probably because of the fact that if the accused does not accept it, it adds to the delay significantly because a new judge will have to be brought onto the case. And also a new jury may need to be impaneled. For summary offences, the magistrate gives a lot more detail. They outline the specific type of sentence and the length of imprisonment, and the prosecution does not need to accept. For indictable and summary offences, if the accused does not accept, then the judge or magistrate will be replaced and they will not be informed of the decision. So that ensures that the accused is not affected by any sentence indication that they do not accept. This, however, adds the delay because a new judge will have to be sworn on, a jury may need to be impaneled for indictable offences, and so it's a serious time waster. The purpose is to provide the accused with enough information to encourage them to plead guilty. and also to bring prompt closure for victims by achieving quick justice. Sentence indications uphold the principles of justice by facilitating early guilty pleas, which save court resources and also reduce costs and time delays and stress. They're also given in open court by an impartial judge, so it's a lot more transparent than plea negotiations, and parties can be ensured that their rights are being upheld and they're being treated fairly according to court processes. Another strength is that once the accused requests it, they aren't bound to accept that sentence indication, and the next judge won't be affected by that sentence indication. Victim impact statements can also be considered by the judge, which is a plus because it ensures that the victim's concerns are reflected in the decision. However, the prosecution has to give consent for indictable offences, which may undermine the accused's ability and opportunity to receive a sentence indication. And often sentence indications are given before all the facts of the case are presented to the court. So the judge may not actually be aware of a lot of the facts of the case and the implications of the accused actions. And that may mean that the decision may not reflect the facts of the case or the severity of the accused actions. And as we said before, there are a lot of delays if the accused chooses not to accept. Finally, sentence indications uphold fairness because it's given by an impartial judge or magistrate in open court. And as we said before, the accused will not be affected if they refuse to accept the sentence indication, as the new judge or magistrate was not informed and they won't be influenced by the prior judge's indication. Equality is upheld as the indication is given by an impartial judge. Access is upheld because it reduces cost and time by facilitating an early guilty plea. Fairness, however, is undermined because it's given before all the facts of the case are presented to the court, which may mean that the decision does not reflect the severity of the case and the accused actions. Equality is undermined because the prosecution can refuse an indication for indictable offences, so this may mean that the accused is at a disadvantage for indictable offences. And finally, there are significant delays incurred if the accused does not accept the indication, and that's because the new judge will need to be sworn on and a new jury will need to be impanelled, which undermines access. So that brings us to the end of lesson 2. In lesson 3, we'll be covering the court hierarchy, key personnel, sanctions, sentencing factors, and reforms. I hope this video was helpful.